Respected ma'am and dear participants, a very good evening to all of you. I.D. Sabras, member of Legal Vidya, welcome you all to AIBE course. So this marks your ninth class of this course. Without any further ado, let's begin the class. Over to you, ma'am. Yes, ma'am. Unmute the mic.
Thank you, Rishabh. Good evening, everyone. Let us start with our today's session. And in this session, we will be dealing with law of taxation and information technology law. Let me share my screen. I think you have not allowed me to share my screen.
Just wait a minute. Now, ma'am, you're able to access.
Yes, thank you. So in today's session, we will not be dealing with whole Bear Act, or we will not be reading the definitions, everything, etc. from the Information Technology Act or the IT Act. But what I have analyzed from past year questions from AIB, that from these two subjects, or you can get questions from any sections, right? So what I have done is I have taken questions from the past year question papers from both the acts, and here we will be solving these questions, and we will see as to how we will navigate to our bare acts to find the answer. Because now you are only left with 2 days before your examination, so it is not possible for you to read all the sections of both the laws, because it contains a large number of sections, and also it is not practicable that you will be able to remember all the sections if you even read it, or if you are able to mug up if you are able to go through all the sections. So here we will be solving the questions, and I will be telling you as to how and from where we are getting the answer from a particular for a particular question. Okay, so let us start with law of taxation itself. So the first question is which provision of Constitution of India states that no tax can be levied or collected except by the authority of law? Now this is a question which is related to Constitution of India, but at the same time it is also related to law of taxation. And here this you have to remember, because there are some provisions from Constitution that as a law students or the lawyers, legal professionals, we are always required to know the basics. So this section is among that list only. So if you are not remembering, then also in AIB you will be having the bare act of Constitution also. So all you are required to do is go to the content of Constitution of India, and you will find the answer. However, section 265 is one of the basic provisions of Constitution which everyone should remember, and therefore the right answer is section article 265, where it is provided that no taxes could be levied or collected except by the authority of law. Okay, next is, as per the Income Tax Act 1961, a person is said to be a resident of India in any previous year if he had been in India for a period of how many days? So the intention of question is to ask you what is a previous year. Number one, for solving question you have to know what is a previous year, and also the time period for which a person will be said to be a resident of India. Now to solve this question, what we will do is we will navigate to section 6 of the Income Tax Act. Okay, ऐसे क्यों हो गया? I think my connection is not stable. Now my screen is visible to you, right? Okay. Sorry, I had to fix the network connection. So we were discussing question relating to section 6, and the question was that as per the Income Tax Act, a person is said to be a resident of India in any previous year if he had been in India for a period of how many days? Okay. So we will go to section 6 of the act, which talks about residence in India. And how you will find that it is under section 6? All you are required to do is to go to the content clause. Okay. And in the content section, you will see that the scheme of the chapterization which the income tax hold under section 6, it provides for residence in India. So section 6 says that for the purpose of this act, an individual is said to be a resident in India in any previous year if he is in India for that period, for a period or periods amounting in all to 182 days or more. Okay. So it is as simple as that. All you are required to do is just to go to the section and you will find the right answer. So the right answer will be 182 days. Okay. Coming on to the next question. Income is defined under which of the following provisions of Income Tax Act? So this is the basic, or you may say that it is a most fundamental question which you may expect from law of taxation. Now, under the definition clause, you will go and you will see that it is defined in the section 2 clause 24. Okay. This is the clause which defines income, and it is a long clause, and it defines a lot of categories from where whatever gain you have will be called as income. So the right answer will be it is 2 clause 24. Okay. Next is section 2 clause 24 of the Income Tax Act comprehensively defines income to include profits, gains, and other taxable amounts. Okay. Sorry. This was the explanation. Now the next question is which of the following would be the first previous year in case of a business or profession newly set up? Okay. So what you have to focus upon is if a business or profession is a newly set up. Okay. And the setting up date of that business is 31st March 2020. Now, as per the provision of Income Tax Act, what you are required to do is to find which would be the first previous year in this case. Okay. Now, the Income Tax Act says that the financial year which precedes the date of setup is treated as the previous year for the tax purposes. Okay. So therefore, since this business is set up on 31st March 2020, so the previous year, the year which is preceding, the financial year which is preceding this date will be the previous year for this purpose. So the right answer will be 1st April 2019 to 31st March 2020. Okay. Because financial starts from 1st April, okay, and it ends on 31st March, okay, of every year. So any financial year preceding March 2020 will be what? From among the following, it is not 1st April 2020, it is not 1st January 2020, and it will not only be 31st March 2020. It will be a complete year which will start from 1st April 2019, which is a year back of 2020, and it will end on 31st March 2020. So the right answer will be option A. Next is, for an individual to be deemed to be a resident in India in any previous year, one condition is. Now, this is also the same question which we had already solved. So, you may find, I have seen this track, you may say, in AIB, there are number of questions, mostly the questions which are asked from the law of taxation. You will find something like that. What is income? What are the categories under income? So you will have to focus mostly on the definition of income. Then you have to be clear about all the days regarding the financial year, the previous year, or any year to be counted, or for regarding residence. So you have to focus on these specific topics mostly. So answer is same. It is 182 days or more during the previous year. Okay. So I have also seen this type of question. This was the AIB which I also appeared. So Mr. Kapoor purchased a residential house in January 2021. Okay. And he purchased it for 80 lakh rupees. He sold the house in April 2022 for 94 lakh rupees. Now he gained 14 lakh rupees, which is arising on account of sale of the residential house. Under which category the income which he gained, that is 14,000 rupees, 14 lakh rupees, will be charged to tax. So the head which will be, which under which it will fall will be, you will find it under the definition from income. Okay. And it will be enough to know. Usually all the incomes or all the capital which you gain from sale of any property, any capital asset such as house, then it is taxed under income from capital gains. Okay. So this will be this gain of 14 lakh rupees will be taxed under this head, the income from capital gains. This you will also find under, this you will find under 2 clause 24. Moving further, Mr. Manjot is a trader.
Ma'am,
Yes, Pari.
sorry, ma'am. We will find the definition of every head in the under section 6, right?
Under section 6, no.
Sorry,
Section
section
6
2.
talks about, yes, section 2, yes, yes.
Yes, yes. Okay, okay.
Let me show you. See. Now, section 2 clause 24. Okay. So, 2 clause 24 tells about what income includes. Number one is profit and gains, then dividends, then the voluntary contribution received by trust created. Sorry for interruption. So you will see here there are number of clauses. It is a very long clause, and it includes all the types of head which will be considered as income. Okay. So this is how all the heads have been mentioned here. Now let's go back to our questions. So the next question is, Mr. Manjot is a trader and he is supplying goods from Delhi, Punjab, Uttar Pradesh, and Jammu Kashmir. The supplies include taxable and exempted items. Okay. So in which state is he required to take GST registration? Now, for the purpose of GST registration, in all the states under the GST law, all the state in all the state registration is required where taxable supplies exceeds the that prescribed threshold will be prescribed by all the respective states. Okay, so therefore here data has already been provided by the question itself, and it provides that in Delhi taxable supplies limit is 21 lakh. In Punjab, exempt supplies limit is 6 lakh. In Uttar Pradesh, taxable supplies is 3 lakh and exempted supplies is also 3 lakh. In Jammu Kashmir, it is 8 lakh and exempt supply is 3 lakh. Now the question is asking in which state he is required to take GST registration. Okay. So the right answer will be Delhi, Uttar Pradesh and Jammu Kashmir, because since exempt supplies do not count towards the threshold, no GST registration is required in Punjab, because in Punjab only exempt supplies threshold has been provided, and it is not talking about taxable supplies. So in Punjab he will not be required to register for the purpose of GST. Otherwise, in Delhi, Uttar Pradesh, and Jammu Kashmir, you have to register. Mr. Manjot will be required to register. Now, the next question is talking about the primary GST slabs for any regular taxpayer are presently pegged at. For this, you have to remember, you have to be aware about the recent tax slabs which have been set up by the government in every budget. Okay, so this is talking about the so if it is talking about the present, then you have to be aware about what has been set up in the year 2024. Okay, what slabs have been has been set up, and it is 0%, 5%, 12%, 18 and 28%. So this is how for GST purposes GST slabs have been set up for this financial year. So for the purpose of law of taxation, just go through the income tax slab also and GST tax slab also before appearing in the examination. Just remember that, because you will not find it in the bare act, but maybe there may be a question from this topic. So just go through, check on the Ministry of Corporate Affairs website. You will find the GST tax slab, or Google it. Okay. Next is the rate of additional depreciation under Section 32 of Indian Income Tax Act is. So for this, you have to go to Section 32 of the Income Tax Act, and you will find that it is 20%. Oh, sorry. Then the next question is, a company which is not a domestic company will pay income tax at the rate of. So you will find that for a foreign company, not a company which is not a domestic company, the income tax rate has been fixed at 40%. Okay. Now, however, it was 40% when at the time of AIB 16. Now it is reduced to 35%. So you have to be aware of the change in the tax slabs or the rates as per every financial year. So for the purpose of AIB 19, you are required to just check this website. Otherwise, I will also send it by tonight. Okay. Then the next question is, amount of deduction under Section 24 of income tax from annual value is. So all you are required to do is go to Section 34 and you will find the answer. Let me show you. So section 24 provides deductions from income from house property. And the question is, amount of deduction in the section 24 of and for annual value is. So we have to see the amount of deduction which has been provided by the act, and we will see that income chargeable under the head income from house property shall be computed after making the following deductions, namely a sum equal to 30% of the annual value. Okay. And 30% will be 3 by 10 of the annual value. So just uh, read the section and you will find the right answer. Now, the next question is, health and education cess is applicable to all SSCs, all SSCs except companies, individual HUF, or the companies only. So you will find in the act that it is applicable to all SSCs. Then the next question is, provisions relating to GST are inserted in constitution by, and it is well known because it was one of the uh, it was very much discussed amendment. It was it was in controversy also, and it was discussed widely everywhere. So it was Constitution 101st Amendment of 2016. Under Article 279A, GST Council is constituted by. Now again, this question is from Constitution as well as law of taxation. So all you are required to do is navigate through the Bare Act of Constitution Act, and you will find the right answer, that it is the GST Council had to be constituted by the President within 60 days of the commencement of the Amendment Act. Okay. So the right answer will be the President, option C. Sorry, I forgot to put space here. Then the next question is, the definition of money under GST law does not include. So again, what you have to do is, at least you should be aware about the GST law. Otherwise, you can skip the question, because this you will not find in law of taxation. Okay. Sorry, the Income Tax Act. However, the right answer will be the definition of money under GST law will not include the currency held for numismatic value. It will include the letter of credit. It will also include pay order and traveler's check, but it will not include currency held by numismatic value. Next is, according to the Income Tax Act, zero coupon bond means a bond. Zero coupon bond. So you will find that it will mean issued by any infrastructural capital company or public sector company, in respect of which no payment is received before maturity, which the central government may specify by notification. So the right answer is all the above. Now, how we will find that? You have to go to the law of taxation and you will get the answer. Wait. See, so you will find zero coupon bond here under the head of other deductions under section 36. So the options are issued by any infrastructural company or public sector company, no payment is received before maturity. So you will go through the section and you will see. Okay. The next question is, for the first time in India, Income Tax Act was introduced by Sir James Wilson in the year. The right answer will be 1860. It was done after the tax provision was brought up in India after what they call as mutiny, military mutiny, and we call as the First War of Independence of 1857. So therefore, to to get over the losses which was suffered by the crown due to that war. So they brought this tax system where they wanted to tax all the incomes and to generate more and more revenue, so that the crown whatever losses the crown has suffered, it will get fulfilled. So it was introduced in year 1860. This also you will not find in the Bear Act, but again you have to just remember the basics. And this is the basic, that it was introduced by Sir James Wilson during the British era, and it was introduced in 1860. With this, I think we are with this we are done with the questions of law of taxation. You will find questions similar nature, mostly which you can access from the Ware Act itself. There are certain questions which are from Constitution and relating to GST law. So just read the basic of GST. I will share the document tonight, and that will be all for law of taxation. Now let us discuss Information Technology Act. So before we begin with the questions, let us discuss the purpose of the act, because there are certain number of questions which they ask from the purpose itself. So this was enacted on 9th June 2000, and the preamble says that it is an act to provide legal recognition for transactions carried out by means of electronic data interchange and other means of electronic communication, commonly referred to as electronic commerce, which involve the use of alternatives to paper-based methods of communication and storage of information. Also, to facilitate electronic filings of documents with the government agencies, and further to amend the IPC, Indian Evidence Act, the Bankers Book Evidence Act, and the Reserve Bank of India Act, and for matters connected therewith and incidental thereto. Also, so this is the object clause, and the preamble says that whereas the General Assembly of the UN by resolution this dated on 30th January 1997 has adopted the model law on electronic commerce, okay, by UN Commission on International Trade Law, and whereas the state resolution recommended inter alia that all the states which are giving favorable consideration to the state model law, they have to enact or revise their laws in views of the need for uniformity of the law applicable to alternatives to paper-based method of communication and storage of information. And whereas it is considered necessary to give effect to the state resolution and to promote efficient delivery of the government service by means of reliable electronic record. So to apply the international obligation to which India is a signatory, that is the model law on electronic commerce by the UN Commission on International Trade Law in 1997. So India enacted after 3 years this piece of legislation. Okay. So here also scheme is same as the law of taxation. Go through the definition clause, and here you will find questions from any section. There is no I cannot identify what major portions were being asked, right? So you just be handy with your Bear Act, and whatever questions will be asked, they will be direct, and you will find the right answer. So let us discuss the questions now. Number one is IT Act was enacted in. Very simple question. It was enacted in 2000. Government of India passed IT Act with the objective of. Now we have just read the objective. It said that it wants to provide legal sanction to all the transactions for e-commerce. It also said that it wants to facilitate electronic filing of all the documents to the government. And it also said that it wants to amend Indian Penal Code IEA and to punish cyber crimes, etc. So the right answer will be all of the above. The next question is, which among the following are the digital signature certifying authorities in India? Now, this is a tricky question. Why? Because this is not from your Bear Act. It is a question which is something related to your general knowledge of legal affairs. Okay. So let us first know what is digital signature certifying authority, and then we will go to see the Ministry of Corporate Affairs website, and we will see what all authorities are included in this. Okay. Certifying authority. Okay, so section 17 under chapter 6 talks about regulation of certifying authorities, and it says that the central government may, by notification in the official gazette, appoint a controller of certifying authorities for the purpose of this act, and may also, by the same and subsequent notification, appoint such number of deputy controller or assistant controllers or other officers and employees as it deemed fit. Okay, so basically, certifying authority controller will be someone who will control all the certifying authorities, and then there are number of certifying authorities, okay, which will be established at different levels, and their duty will be to supervise everything. Okay, now the question was asking which among the following are the digital signature certifying authorities in India. So you are now knowing what is a certifying authority. So if it is a digital signature certifying authority, this authority uh, is appointed, or it has been framed so that it can certify the issues relating to digital signature. Now, when we go to Ministry of Corporate Affairs website, you will find certifying authorities. Certifying authority has been granted a license to issue a digital signature certificate under Section 24 of Indian Evidence Act. Sorry, Indian IT Act. Really sorry. One can procure class 2 and class 3 certificate from any certifying authority. Now you will see the names of all the certifying authorities which are recognized by NCA here. National Informatics Center, IDRBT Certifying Authority, SafeScript CA Services, SIFI Communications Limited, Code Solutions CA, eMudra, CDAC, NSDL, Capricorn, Pantasign, ID Sign, Verasys, Extra Trust, KFO Sign, SignX, and Pro DigiSign. So basically, now you know, at least you can identify by the name itself that if you are having four options, you will be able to at least now find that, okay, all three will be cancelled and this will be the right authority, because now you know the all the digital signature certificate certifying authorities. Okay, now having read all the names and all the certifying authorities, let's go back to our question. And here we have the options MS SafeScript, NCERT, MTL, and all the above. Now, from among this list, have you seen any of those? Can you find any authority? Yes, Pari.
Safe script.
Exactly. So you will only find that from among four options, right answer is the SafeScript, because it is only authority which has been mentioned here. So what I will suggest you for the purpose of this examination, just remember these authorities, okay? And then from acts and rules, go to the new notifications or new forms, okay? Here you will not find something which is very important for the purpose of your examination, but what I wanted to show you, rules. No, sorry, that will be very hectic for you. Just leave it. Just read what I have told you right now, and after that, move forward. Relating to law of taxation, I will share you the document, and I will share you the important topics relating to the new developments also. Leave it. Moving to next question. Section 3 of IT Act, which was originally digital signature, was renamed as what? Wide IT Amendment Act of 2008. Now, this is also a very straight and very easy question to find. All you are required to do is You have to find where digital signature was originally provided, and then you will find the right answer. So in the IT Act, what you are required to do is go to your content clause, and what has been asked, it is digital signature. Okay, so go to the definition of digital signature if you can find. Can you find? So this chapter is talking about digital signature. Now, since this is an amended act, it is digital signature and electronic signature. So the right answer will be, after the amendment, it is digital signature and electronic signature. So right answer will be option A. It is not digital signature and e-signature. It is not digital and electronic signature. Instead, it is digital signature and electronic signature. Then the next question is, the controller of certifying authority in India must maintain a database of the disclosure record of. Again, we have already seen certifying authority under section 24 of the Act, and there we have seen the provision relating to certifying authorities. So it will be easy to find. All you are required to do is to go to section 24. Also, see, here it is providing about foreign certifying authority. Then you have also seen there are certifying authorities. Okay, so just from the common sense, although it is provided under section 24, but from the common sense you will see that there is something called certifying authority, there is something called foreign certifying authority, but there was no provision regarding cross certifying authority. Okay, no such authority exists under IT Act. So the right answer will be 2 and 3. Sorry, it is not 2 and 3, it is 1 and 3. I don't know why I have done this. So the right answer will be 1 and 3. And oh, sorry, I have missed the options. I will correct it before sending it to you. So the right answer will be first and third. Okay, it is foreign certifying authority and certifying authority. Next is, in the cases before cyber appellate tribunal, the appellant, now options are, the appellant cannot appear in person without legal practitioner. Now this could not happen. Why? Because as per our constitutional rights, as a person who is aggrieved, whose fundamental rights, or there is any kind of violation of his right is there, then as person, you are allowed to appear in the court. Okay, so he cannot appear in person without a legal practitioner is not a right clause. Next, he cannot authorize a legal practitioner to appear on his behalf. Now this is something which is very vague, because in India, everyone is authorized to appear in the court of law with his legal practitioner to appear in his behalf. Now, as per this provision, it is the violation of the fundamental laws, the procedural laws in India. So this will also be not right. Cannot authorize his officer to appear in his behalf. This is also not right. Cannot authorize his relative, who is neither his officer nor a legal practitioner, to appear on his behalf. Now, this is the correct answer. Why? Because someone who is not an officer and someone who is not a legal practitioner is not allowed to appear on behalf of the person who is the appellant in cases before appellate tribunal. And we will find this provision here. Section 48 talks about appellate tribunal, and it says that uh, so this whole chapter was repealed, and there was a lot of amendments due to Finance Act of 2017. However, you will find the provision appeal to appellate tribunal, and here you will find that it is said that sorry, Sorry, in the procedure you will get it. Under section 59, right to legal representation, you will see that appellant may either appear in person or authorize one or more legal practitioners or any of its officers to present its case before the appellate tribunal. So from the section 59, it is very clear that all the three other options are not correct. And this is the right answer, that he cannot authorize his relative who is not an officer as per the provision, or who is not a legal practitioner, to appear on his behalf. Under section 37 of the IT Act 2000, the certifying authority can suspend the digital signature certificate if. So for this question, all you are required to do is to go to section 37. Okay. And under section 37, you will see that subject to the provision of subsection 2, the certifying authority which has issued a digital signature certificate may suspend such digital signature certificate. Number one, on receipt of the request to that effect. And number two, if it is of the opinion that it should be suspended in public interest. Now, what are the options? Subscriber is found guilty of malpractice. The subscriber is involved in cyber terrorism. The subscriber requests for the same, and in public interest. Now, we have seen that only two clauses were present under section 37. So, the right answer will be 3 and 4. Okay. So, this is how you are going to solve the portions which will be asked from the Law of Taxation or the Information Technology Act. Now, for the yes,
Uh,
Pari.
are there not any case laws with regard to taxation? Because I checked the last previous year question papers and it contains it contained case laws also. So, ma'am, do you have any PDF related to that?
Okay, I'll
Okay,
share
I'll
you the
share you the
paper,
paper. Okay, ma'am.
but I don't think that I from which year you have seen that they have asked you this case laws relating to taxation, because in
Because in
recent four
recent
five
four or
years I
five years, I have. Ma'am, it was, I don't remember exactly, but it's not recent. It's old only.
okay.
Okay. Yes,
Okay.
ma'am.
See, AIB has changed its pattern since AIB 16, and it has now the questions are more direct somehow, and there are the case laws are asked from the portions majorly from the constitution, the contract, the law of torts, and the subjects like that. But from taxation, IT, limitation, negotiable instruments act, or even IPR, they are not generally asking the questions. But okay, I will share you the document which contains important case laws from law of taxation, and then I will also share from the IT Act also. So if they may ask, you will be able to do it. Now
Now,
I propose this, that tomorrow, since we will be having the last class regarding our AIB from our AIB crash course. So I propose you, if it is okay for you, all the participants, can we have this class in the afternoon from 3 to 5?
ma'am, I won't be able to do it because I have works in bar council. So, like,
Okay,
can
so
we?
can there be any time frame which is from 12 to between 12 to 5 in afternoon?
Ma'am, can it be done from 4 o'clock?
4 to 6. Okay, because we will be required at least 2 hours to finish all the topics, because there are a lot of portions which we are required to discuss, and there are some minor acts also. So I thought that I will be discussing in detail the professional ethics portion and the Advocates Act, because that is important, and some minor acts which we are left with, and then the law of torts, which is included in the syllabus of AIB, but we have not been able to discuss it. And since law of tort you will not find in the Bare Act also, so it is important that you should remember some basic provisions. So if it is fine with all the participants, we can have the class from 4 to 6. What I will do is, okay, Harjot has said yes. So I will ask, I will ask the coordinators from Legal Vidya to initiate a poll in your WhatsApp group, and whatever answer will be there, we will fix the class from that. Okay, 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 fine. So for today, this is all from my side. I am leaving 15 minutes before, but tomorrow we will cover up by making it 2 hour class. Okay. Okay, fine. And I'll just share you this sample question paper after correcting the one of the answers, and I will share the documents containing case law also. Yes, Komal.
Ma'am, regarding examination do's and don'ts, now we'll be carrying bare acts without notes wala books, and the
Mm-hmm.
income tax act we don't have. Another some of the books we don't have related to majority act and all that. So how do we go about that?
See, what the publishers who are making the sets relating to AIB, what they are doing is they are covering those laws or those acts which are containing the major portions, right?
Right,
AIB is not an examination where you have to be in the merit to get qualified. All you are required to do is to secure 45%. Okay.
right.
So if you are leaving four questions from the Income Tax Act, then
Hmm.
it will not create any major problem. But
Hmm.
again, it will be fine for you. But if you remember anything, or if you may take this
So
PDF,
maybe what
the
you are
sample.
sending us right now, if we go through it, probably that will help us, right?
Yes, you
Instead of
can get it
searching here
printed.
and there.
The app you can get
And
printed.
we can't just do even a dot, pencil mark a little bit in the books.
See, they don't, honestly, they don't check in this much detail. I
Mm-hmm.
appeared in AIB 17, and it was AIB 16 since when they have decided to allow only bare acts without comment. But even after that, in the centers in Delhi itself, in
Mm-hmm.
Gujarat, I appeared in Gandhinagar, and in Uttar Pradesh, in many centers from Uttar Pradesh, where I heard from my friends and colleagues, everyone, and they said that they appeared with the bare apps with comments itself, and
Okay.
some even took the bare apps where they have highlighted and put notes also.
Okay.
So I will not
Suggest.
suggest anything regarding this, because this may there may be now this is a question of chance. So if you
Right.
are getting an invigilator which is not very strict, you will be
I'm just wondering because we have been called at the center at 8:30. Is it because of checking on the entire book whether there are any markings or
no,
whatever?
no, no. They will not be checking all that. In fact,
Mm-hmm.
I went with a bare act set without comments. I purchased it before the date of examination. It was very
Mm-hmm.
costly also, but then no one checked in. I saw people who were having carry bags containing lot of books. So all they did is that they said that books are not allowed. You can take your bare acts only. And then people went
Okay.
in with their bare acts with highlights and notes, etc. Some participants, sorry, some candidates like us, we raised objection that it is not allowed, and they said, okay, this is fine, and they went to some supervisor of the center, and they talked with that,
Mm-hmm.
but then nothing happened. An exam got over,
Okay.
and they all were able to do that. So I'm not
Mm-hmm.
promoting unfair practices, but yes, be equipped with all the necessary bare apps, and it will be fine for you.
Okay. So it's a kind of a taking a risk also, even if you mark there's some
Yes, yes.
professor or
Uh,
something might
so if you are putting any very
maybe not
invisible
that.
type or very short mark, that will not be cached, or it will not be creating any issue.
Yeah, just a small tick mark or a dot maybe with a pencil or a black whatever. Let's see.
I think pencil is good. Yes, Pareen.
Ma'am, actually, I bought the set. So I bought it yesterday, but it doesn't contain the new Criminal Amendment Acts. So,
Okay.
ma'am, uh, I'm not very I'm very clueless right now. Should I just go and buy, because they are not. I can't find any shops where they are providing the criminal acts amendment acts without the comments, and also I have to, like, it is sold with the whole set. So I'm not getting any
Yes.
separate. Yes, ma'am. So what should I do,
You
ma'am?
just you just get it printed. Just download the PDF. I have or I will, if you say, I will share the PDF of the new criminal act, and just get it printed if you are needing.
Yes, ma'am. Okay, ma'am. Ma'am, one more thing is that they're allowed. They will see the front page also if it is like it's written the official gadget of India. It's written there. You have that set with you, right? PDF.
Yes.
So
Yes.
okay,
So
okay,
that
ma'am.
will
So
not create you any problem, because the official gadget document was is without any comments. Okay, illustrations are there, and illustrations are allowed. Illustrations are part of Bear Act.
yes, yes, ma'am. Yes, ma'am. So that is without notes and comments, right? So
Yes, yes, yes.
okay, ma'am. So ma'am, please
Notes
share
and
it with me.
comments are added by the publishers of the Bear Act. So since I
Okay.
have downloaded it, or you may download it from the official website itself of the government, it will not contain any notes or any comments.
Ma'am, you can just can you please share it with me through WhatsApp? I'll
Okay,
send
I'll
you a.
share all the Bear Acts. Yes, I will share the Bear Acts of the new criminal laws.
Sure, ma'am. Sure. Ma'am, in the group itself, you'll share.
I am not part of the group, but I'll share with the coordinator of Legal Vidya, and he will share it to you.
Okay, ma'am.
Any other queries?
Yeah, like for example, any question coming from IPC or BNS. All
Okay.
right. So like you had given one table, comparison table. Like earlier
Yes.
in IPC, it was this section, and now it is this section,
Yeah, but
right?
it will not be allowed. That document will not be allowed. It will not be
No, no, not
counted.
the table. I have this BNS ka Barrack book. Okay,
Okay.
in that there is a comparison table.
Yes,
So my
exactly.
question,
So the Bear Act, which the publishers are publishing regarding the new criminal laws, they are providing the comparison table also.
correct. So my question to you related to that is like if they ask specifically like IPC may 1860 may which section it is, then we can mention IPC. Ka. Otherwise, we have to write BN refer to BNC award section 77. Like for example, stalking, it's section 78 in
So
BNS.
I think in the questions, since this is the first time they are doing it after the passage of the new criminal laws, they will be very clear about from which of the act they are asking. Is it the question is from the new laws, or is it from the old laws itself?
Okay. Okay. Yeah, because it's a brief, so many it's a very big table of
Yes, yes.
358 sections. Yeah, fine. I'm done with my question.
Okay, okay. Is there any question from any other participant? Okay, so I suppose this is all for today's class. You may end the session.
Sure, ma'am. Thank you so much, ma'am. Thank you so much, participants, for joining. Good night to you all.
Good night.